Over the years, Australia signed up to several international treaties, committing itself to follow the rules laid down by international law. So does this mean, domestically at home, when we read the law in Australia, we should also think about international law and incorporate them into how we interpret our laws in a way that is consistent with them? This question came up before the High Court after a Malaysian man named Alhin Teo came to Australia on a temporary entry permit in 1988. He later married an Australian citizen who, at that time, already has children of her own, and the couple went on to have more children. Teo applied for a permanent resident visa, but while that was happening, he was convicted of importing and possessing heroin. Teo was sentenced to 6 years imprisonment, and subsequently, his visa application was refused on the basis that he was not of good character. He requested a review of the decision with the Immigration Review Panel, but the panel affirmed that decision and recommended Teo to be deported, despite evidence that his wife and children would suffer terrible financial and emotional hardship if that were to happen. Teo then appealed his case to the federal court. He initially lost that appeal, but was then successful on his second appeal before the full court. The immigration minister appealed to the High Court, asking for that decision to be reversed and have Teo removed from the country. The High Court dismissed the appeal and referred to the United Nations Convention on the Rights of the Child, holding that by virtue of Australia's ratification of that convention, Teo had something called a legitimate expectation that the best interests of his children would be a primary consideration in the minister's consideration of his application. Legitimate expectation is a principle of administrative law. Government decision makers, like the immigration minister, should be required to fulfill the legitimate expectations of people in their decision-making process. In an administrative process, it is reasonable to expect that a person will be treated impartially and have their legal rights recognized. It is not just a mere hope that something will happen, but is actually a legitimate, reasonable, or well-founded expectation in that process so that it is fair. This effectively extended the range of protections given by the common law rules of natural justice. In this case, despite Australia having signed up to the Convention on the Rights of the Child, the immigration minister did not recognize the interests of Teo's children in arriving at the decision to deport Teo from the country, which means that a legitimate expectation was not fulfilled and therefore amounted to a denial of procedural fairness. Normally, when Australia ratifies an international treaty, that alone does not automatically make it a part of Australia's domestic law. Those provisions need to be separately incorporated into Australian law by Parliament enacting a legislation saying so. This is because Australia's constitutional system, the executive in the exercise of its prerogative power, signs the country up to treaties, but the power to make and alter the law lies with Parliament. So a treaty which has not been enacted into Australian law cannot itself be a direct source of individual rights and obligations. In this case, the provision of the Convention on the Rights of the Child have not been written into domestic law by Parliament. However, the High Court thinks this does not mean its ratification holds no significance for Australian law. When the meaning of a legislation is ambiguous, the courts should favour that construction which accords with Australia's obligations under a treaty or convention to which Australia is a party, at least in those cases in which a legislation is enacted after or in contemplation of Australia's entry into or ratification of the relevant international instrument. That is because Parliament, in a way, intends to give effect to Australia's obligations under international law when drafting a legislation. A legislation is to be construed and applied as far as its language permits so that it is in conformity and not in conflict with international law. If the language of the legislation can be read in a way it is consistent with the terms of the relevant international treaty or convention and the obligations which it imposes on Australia, then that interpretation should prevail. Accordingly, because the laws under which the immigration minister sought to deport Teo from Australia would be consistent with the Convention on the Rights of the Child, the High Court found a legitimate expectation to exist, as Teo would have expected the minister to also consider the interests of Teo's children. It is important to note that such a principle of statutory construction is subject to many limitations and should be applied cautiously. This principle only goes to guide the interpretation of the language of the Australian legislation and does not itself import the terms of the treaty into law as a separate source of individual rights and obligations. However, in relation to the notion of legitimate expectation, less than a decade later, 4 of the 5 members of the High Court expressed strong reservations about using international law as a basis of having a legitimate expectation to protect rights in Teo, but just fell short of expressly overruling it. Finally, in 2015, a majority of the High Court firmly rejected the concept of legitimate expectation, calling it unnecessary and unhelpful. Instead, the real question that should be focused on is whether the requirements of procedural fairness were fulfilled. Now, as a general rule, Administrative decision-makers must accord procedural fairness to those affected by their decisions, unless there is a clear legislative intention to the contrary, which is determined by considering the circumstances of each case. Teal was a case in which the concept of legitimate expectation found its way into Australian law for a brief moment. Although ultimately overruled by the High Court, to this day, Teal continues to be cited in court decisions. In immigration matters, it is cited to argue that the immigration minister must afford procedural fairness to visa applicants. In matters where children are involved, it is cited to say their best interests should be taken into account as consistent with the Convention on the Rights of the Child. In other matters generally, it is cited for its principle of interpreting Australian legislations in a manner where consistency with Australia's international obligations is preferred.